Hi everyone, it's Attorney Knighton and I'm here with Attorney Jackie Messler. She is a estate planning attorney with Davis & Kuthau, and we're talking today because Jackie can help you now that your case is close to resolution or is resolved with planning for your assets for the future. Hi Jackie.
Hi, thanks for having me.
So Jackie, the clients listening to this are close to the end of their divorce or have just finalized it. And their marital settlement agreement outlines all their assets and debts, as well as comes up with custody and placement. And I thought now is a good time for me to talk to you and interview you so our clients know what to do next. So, now that they have all their assets divided and custody and placement decided, how can you help them?
Sure. So when I'm first talking to a client about doing their estate planning, we typically send out what's called an estate planning questionnaire, which can be a little bit of an overwhelming, document to receive because it does ask, family and financial information. It asks who you would want to serve, if you become incapacitated, would you want to make healthcare decisions for you, financial decisions for you, would you want to serve as the guardian? So it can certainly be a little bit overwhelming. But, as you mentioned, the marital settlement agreement is going to have a lot of that information. And, probably also in your file, you're going to have a lot of that, basic information that I need to start on the estate plan. So it does make sense to, have the divorce attorney and the estate planning attorney work together so that we can, save the client some time, basically, on having to come up with all the information together. So again, when I'm starting to meet with clients, I usually try to gather all of that information ahead of time, just so that we can have a bit more efficient meeting and then productive meeting on what kind of estate planning needs to be done.
And when we're talking about estate plan, I did a video already with Attorney Messler, and it's on our website, about what an estate plan is, but we're basically talking about wills, trusts, and powers of attorney. And so, this does make it easier that, we can help by passing the information along to Attorney Messler if you don't have it. Or, again, we want to just make this process easy. I mean, what would happen if people don't get this document, a document like a will or a trust or a power of attorney done?
Sure. And in the context of, finishing up a divorce, if you had documents in place while you were married, generally speaking, the divorce is going to nullify, any assets going to the ex-spouse, and then any, if you had named the ex-spouse as healthcare agent and financial agent, that's going to nullify that. But at the same time, it is necessary really to have an overview of what is in place now that the divorce is finalized. And so, you want to update that power of attorney, healthcare, and just make sure that, you're naming somebody else, or, you have that first agent set out, and you have that second agent set out if the first agent couldn't help you. Same thing with the financial power of attorney. You want to make sure, there is a plan in place. And so you just, it's worthwhile to update that. And then as far as, the disposition of your assets, so in your will or your trust, I'm sure you don't want anything to go to the ex-spouse other than what the, marital settlement agreement might require, as far as maybe life insurance policies in place for the kids. So, you want to set out the new plan of what would happen to your assets. And one thing that, we definitely want to check is let's make sure that the beneficiary designations are updated on your, 401ks and your IRAs and your life insurance policy, again, within the requirements of the marital settlement agreement. So we want to just make sure that, we know what the plan is and get that updated to, benefit whoever your beneficiaries are after the divorce.
And those checks are invaluable because after you get done with the divorce process, many clients are a little worn out. And so to make certain that, the assets go to who you really want it to go is really, really, really important. So I want to understand, what can the clients expect if they pick up the phone and call you? What are the steps that you normally do?
Sure. So, if we're working together with your firm, we certainly can try and get as much information as we can from you so that we're not, again, asking the clients to come up with information that they've already listed for you. But so we gather information. I would typically set a meeting with the client, and we would cover, in that first meeting, what documents do you have in place? Does it make sense, or do we need to update the documents? We talk about, what does it mean to go through a probate? If you have a will, typically your will governs probate assets. So we would talk about, what does it mean to have a will and go through a probate? What benefit does a revocable trust have? And so we would really, talk about the nitty-gritty appointments and information to be able to draft all of those documents. So then at the end of the meeting, depending on what the client wants and what the client has told me for, what should be in the documents, I can either give them a flat fee, or I can give them, a range of prices where I think that the estate plan will cost, because I don't want to have any kind of surprises when I'm sending out the bill. So then, assuming the client wants to move forward, what will happen is I'll draft the documents, and then I will, when they are ready to send out, I will send them out either via email, if that's how the client prefers to receive them, or I can mail them to the client, give them a chance to really read through it, sink in, just make sure everything is correct, and then we would set up an appointment to sign the documents. So, just depending on if I do have all the information I need, and then we get all of the questions I need answered at that first meeting, it's typically, from start to finish, it might be a couple of weeks, 2, 3, 4 weeks of turnaround time from, the time that we, first start talking to the time that the documents are actually signed.
Great. And lastly, I know that people are going to be thinking about it. How do you determine fees?
Yeah, so that, in that initial meeting, we will talk about the two general types of plans. It's not that it's, one size fits all, but there's typically, a simple will plan that would say, if you have assets that are subject to probate, those assets would go through probate. So the will plan would include, a will, financial power of attorney, a healthcare power of attorney, and then also a HIPAA document along their agent's access, HIPAA protected medical information. That is typically in the range of $800 to $1,200, just, again, depending on the plan. A revocable trust plan, on the other hand, would, typically the planning is to try and stay out of a probate at the client's death. And then that plan would include the trust, also a will, and, the will, as I said, only covers probate assets, but we still have a will in place. And especially for those clients with minor children, the will is in place to nominate a minor for those guys, nominate a guardian for those minor children. And it would still include that healthcare power, financial power, and HIPAA document. That's typically in the ballpark of $2,000 to $3,000, just depending on, again, what the client wants.
Well, your service is invaluable, and I know it's not something that people typically think about, but, I'm advising clients to really move forward with getting their estate plan done as soon as the divorce is done. It will give you peace of mind knowing that all the hard work that you put in to divide your estate, to come up with a plan for your kids, isn't undone after all this time. So, Jackie, I'm going to include at the bottom of this email your contact info. You can call Jackie directly at her office, which is 262-792-2409, and she's with Davis & Kuthau. Thank you, Jackie.
Thank you very much.